Alright, I think I've got good audio here. So, let's get into this. The last 3 weeks, we have all been on our pins and needles just waiting for this verdict to come down for Kyle Rittenhouse. How awesome is it that it is a not guilty verdict? Self-defense was clear from the beginning. The fact that they even brought these charges and kept fighting, and then, as we'll go through in this complaint here, lied, manipulated evidence. These prosecutors did everything in their power to get Kyle found guilty, and they failed. When all the decks are in your favor and you still fail, wow. So the prosecutor, just so everybody is aware, I know there are lots of lawyer jokes. There's lawyer jokes out there, so many of them. But lawyers really do have a code of ethics. They really do are supposed to have a higher standard than us as non-lawyers. Prosecutors, since they work for the state, they should be held to an even higher standard. I understand they aren't, but they should be. Just as I think cops should be held to a higher standard, pastors should be held to a higher standard. I hold my pastor to a much higher standard than I hold myself. And that is because of the positions that they hold. So today I went ahead, because I watched the entire trial. Every second of the trial I did watch. And my mind is just blown by the actions of the prosecutor. So we're going to go through this mock Wisconsin bar complaint. I'm going to try to remember to share a link to it in the description below. But this bar complaint is made against lead prosecutor Thomas Binger and James Kraus. All counts are pled against Mr. Binger. As lead prosecutor, he oversees any member of his team and is responsible for any evidence turned over to the defense. Count number 1, suburban perjury as to Sal Condry. Mr. Binger knowingly placed Sal Condry on the stand, knowing that he would lie on the stand, and there was evidence on that lie. Specifically, Mr. Condry took the stand to testify that he did not want people on their property to protect it the night of August 25th, 2020. This was contradicted by the photo evidence of Mr. Condry posing with those who showed up to protect his place of business. There was also video evidence of Mr. Condry getting out of his van with Kyle Rittenhouse, Dominic Black, and Dick Smith after giving them a ride from one business to the other. The prosecutor's own witnesses testified to the truth of the matter, and it should have been known to Mr. Binger what the truth was. Mr. Binger knew, or should have known, that Sal Condry was lying when he was put on the stand. So remember, the prosecutor's own witnesses, Dominic Black, who was Kyle's friend, testified that Nick called him and said, "Hey, we were asked to protect this business. Will you come down?" And then, can't think of his name right now, but the other guy that was a prosecutor witness, but was also holding an M6 or AR-15 and walking amongst the crowd. He testified that when he got to the car lot, Sal said that yes, he'll take their help. So Sal and Sam both said it, because both Sal and Sam were there. It is just insane. You are the prosecutor. Now again, you guys, they can have witnesses lie on the stand, and that's not bad in itself to have a witness lying on the stand. But if you know what they are going to say is a lie, that is misconduct. And then basically the same thing for Sam. I changed a few of the words in here because he was the one that took the photo, he didn't pose in the photo. Constitutional violation, Fifth Amendment questions. During cross-examination of the defendant, Mr. Binger had to twice be told not to ask questions related to Kyle Rittenhouse's right to remain silent prior to testifying. Supreme Court precedent has ruled that remarking on a defendant's rights to remain silent is highly prejudicial. This questioning was done in bad faith and was a blatant violation of Kyle Rittenhouse's constitutional rights, including his Fifth Amendment and his Sixth Amendment right to a fair trial. So you guys, don't talk to cops when you see them. They want to ask you questions, tell them no. I don't speak without an attorney present, and even with an attorney present, I still don't answer your questions. You are not required to answer questions to a cop. And that you holding that right cannot be held against you in front of a jury. Sixth Amendment violation. During cross-examination of the defendant, Mr. Binger had to twice be told not to ask questions related to evidence the judge ruled before the trial would not be admissible. In front of the jury, Mr. Binger asked, "Is it not true that 2 weeks previously you made a comment about protecting private property before the defense or judge was able to stop him?" During deliberations about this violation, the judge responded to Mr. Binger's excuses with, "I don't believe you. I do not believe you had good faith belief to think that the rules have changed." He further found that even if Mr. Binger had reason to believe the judge would change his mind, he knew that that was a conversation to be had outside the presence of the jury. By asking the question in front of the jury and requiring the defense to object, leaves the jury wondering what exactly Kyle had said about protecting property 2 weeks prior and why the defense is so afraid of it. Asking the question in front of the jury was a clear violation of the Sixth Amendment right to a fair trial. And you guys, this was talked about before the trial in the pretrial motions, and the judge made a certain ruling. And so this is all motions in limine and all that stuff. So typically they don't like to hash things out in front of the jury. They don't like to pause and start to hash things out in the middle of the trial. They like to have all these things argued about before the trial begins. And so the fact that he went down this road and he even opened that door of questioning was wrong. It should have never happened in front of that jury. Brady violation, manipulation of evidence. A week into trial, the evidence fairy managed to drop off drone video evidence of higher quality at the prosecutor's office. When first questioned about it, the prosecutors claimed they didn't know who dropped it off, then later changed their story that they knew who dropped it off. The facts on this drone video are troubling, and I will list them below. The person who dropped off the drone video list was listed on the prosecutor's witness list read to the jury. The video provided to the prosecutor was alleged to be from Tucker Carlson's show. However, Tucker Carlson only showed the video starting at the second Mr. Rosenbaum threw a bag at Mr. Rittenhouse. The video provided by the prosecutor to the defense was of much lower quality. How it was manipulated is a matter to be found under oath. However, the prosecutor claims it happened when he emailed the file. This claim is, I'm going to add, blatantly untrue, as evidenced by the renaming of the video file. Even if the file was compressed by email, it would not have changed the name of the file. Now, you guys, I've said since they first started arguing about this on Friday and then on Monday, that file, you only get by the name of the file being changed is key. That is the key piece of evidence. If it was just compressed with the same file name, I would actually buy the prosecutor's arguments. I still think it would be grounds for dismissal, but I would buy their arguments. But the fact it was of a different name. Remember, the original file had a long name that included the date, time, and all that junk. The new file that was emailed to and sent over to the defense was IMG_05. Now, I downloaded Handbrake, which happened to be a program that is installed on Kraus's computer there. And when I saved a file, compressed the file, the video file, it happened to be named IMG_01. Coincidence? I don't know. Since the defense was given a horrible version of the video, they had no opportunity to review the video, nor did their video expert have an opportunity to examine it. This drone video became the centerpiece of the prosecutor's case that a few pixels show Kyle aiming his pixels at others in the crowd for one frame. No eyewitnesses testified to this. The better quality video wasn't turned over to the defense until after both sides had rested. So, case is closed. It's time for speeches. Oh, yeah, we'll give you the evidence now. No problem. You can have the evidence all you want. That is not the way we work as a society. That is not justice. Mr. Kraus, in defense of his actions, blamed the police, his lead prosecutor, and the defense team themselves for his actions. He said it was their fault. Yes, he said that in court. It was their fault. Oh, and that pissed her off. Oh, I loved seeing it. But anyway, you guys, go back. Many of these channels are holding the entire case on their YouTube channels. They all streamed it. That would have been Friday the 26th. Go watch it. It wasn't a full day. I think it was about 4 hours. It was fun. It was amazing. And, I just watch it, you guys. Don't take my word for it that it was good, that it was hilarious. You need to watch it. It was that good. Brady violation as to jump kick man. Mr. Binger lied to the court and the jurors on multiple occasions about not knowing the identity of Jump Kick Man. Maurice Freeland has been identified as Jump Kick Man. Mr. Freeland lives there in Kenosha and went to the prosecutors to ask for immunity on other charges in order to testify. This information was not relayed to the defense, making this a Brady violation. Also, Mr. Binger's repeated lies about not knowing who it was to the court is a violation of the Code of Ethics. Charged for illegal possession of a firearm. Now, as far as a bar complaint, you would add stuff like fluff like this. I don't think on its own count 7 would stand. But with the rest of the complaints, with the rest of the counts, I think it helps. By bringing a charge of a minor in possession of a firearm was gross misconduct. Mr. Binger read line 1, which states if a minor under 18 is in possession of a dangerous weapon, they are in violation of the statute. However, as an attorney who has practiced for nearly 30 years, Mr. Binger is aware that you read statutes in their entirety. You do not ignore the parts of it that you do not like. Paragraph 3 of the statute gives exceptions. Since Mr. Binger kept referring to this charge throughout the trial, the jury heard it many times, contaminating their thinking. The charge was not dismissed until jury instructions were being argued. This charge should have never been brought. The judge should have dismissed it before the trial. The jurors should have never heard a word about it. Okay? Those are things to be argued about. Again, before trial. But they heard it. And they kept hearing it. Again, Mr. Binger had no case, and he knew that about the actual assaults. All of his witnesses testified that yes, Kyle was in fear of his life, that they felt fear for him. His own witnesses said that. So, he knew he had no other case. Everything hinges on the fact that Kyle was carrying a gun illegally. And that was brought in bad faith. And as attorneys, prosecutors, you do not do that. Again, let's hold our prosecutors to the highest level of competence, to the highest level of ethics. Let's not, if there is a guilty verdict, let's not put let's not put that in question. What that verdict, we want, as the public, I want to rely that every guilty verdict was because the man was guilty and not because the prosecutor created lies, manufactured evidence. All this misconduct that happened in this case. That's exactly what we don't want to see happen in a prosecution. That's what we joke around and say that that's what we expect from the defense. And that's not too far off. Some defense attorneys would do stuff like that. Still unethical. However, prosecutors, and here you guys, this is from the bottom of my heart. I want to know that every single time somebody is found guilty or is charged with something and they are found plead guilty or something, that is because the law was on your side. I do. I want to believe that from the bottom of my heart. I want to trust in that. These prosecutors, with their manipulation of evidence, with all their different violations here, they have removed that trust. I hope that going forward, every case Binger and Kraus charge, in every case they have ever filed, is looked at with extreme prejudice. Their actions during this trial were so egregious that it erodes the public trust, which is all the government has. Alright, you guys, what did you think of this bar complaint? What did I miss? I'm sure you guys saw something during the trial that I missed or maybe just forgot to include here. Let me know. Some things I decided weren't real bar complaints, and I just realized misspelled the whole thing. Fix that on camera here. And there we go, you guys. Let me know what you think. Have a great one. Thank you.